looked at the logo, the union's logo and Trader Joe's logo.
Yeah.
I see a lot of similarities between them, but I also see some differences. One of the primary differences is in the middle of the Trader Joe's United logo is a fist.
It's Trader Joe's United in a circle, raised fist, holding a box cutter. Trader Joe's, of course, has the stylized Trader Joe's name, but it also has that sort of market basket, also in a circle, although to me, I don't know that that's such a similarity. I mean, there's a lot of logos that appear in a circle, but this raises several issues under intellectual property law. The biggie, of course, is trademark infringement. Trademark infringement requires a likelihood of consumer confusion. But Trader Joe's also brought a claim for dilution, which doesn't require a likelihood of confusion. Basically, dilution is reserved only for famous marks, but you don't have to show likelihood of confusion. What you need to show is that the other person's, the Trader Joe's United use of a similar mark is likely to dilute Trader Joe's ability to distinguish its goods and services because folks are making another similar association with a similar mark. So it's blurring the distinctiveness. Now, another issue that this raises is something called nominative fair use.
Tell me about that.
Yeah,
nominative
fair use basically says, look, it's not necessarily confusing or a dilution if a third party, like a competitor, is using another competitor's mark simply to name or describe Trader Joe's. So in the union context, you can understand that we're a group of employees from Trader Joe's and we're looking to unionize. We have to, in some way, use the name Trader Joe's in order to indicate that we are attempting to form a union of Trader Joe's employees.
That's right.
So that is a fair use of the Trader Joe's name. One of the things that Trader Joe's was careful in its oppositions was to say, we aren't saying that the union can't use the name Trader Joe's because that would be nominative fair use.
Right.
We understand that.
Yeah.
We just don't want them to use it in the commercial context. To me, that's a
commercial context meaning selling
the mugs, the tote
bags,
bags, right? But to my mind, I don't know how you can say both things at the same time, right? If it's nominative fair use to say we are Trader Joe's United, and Trader Joe says, yep, that's fair, on your website, talking about your union, et cetera, but you can't put it on a tote bag or a mug.
Right.
So one of the things that the lower court talked about in terms of the nominative fair use and the context, and so why the lower court did not find a plausible claim of infringement or confusion because of the context. So the only way to buy this merchandise is if you're on the union's website.
Right.
So how is that consumer going to be confused into thinking that it's buying a Trader Joe's grocery store tote bag? The Ninth Circuit said, we really need to develop the record more. I don't think it was appropriate to dismiss just on the face of the complaint. Fair enough. But the issue that isn't mentioned in the cases that I see is what about post-sale confusion? One person on one side of the street has a Trader Joe's grocery store tote bag. Person on the other side of the street has a Trader Joe's United tote bag. Third person walking down the street, are they going to be able to tell the difference? Are they going to be confused? Is there any distinction that consumers are going to be aware of because they're no longer in that point of sale context? So that wasn't raised, but it's certainly an issue and will more than likely be raised as the parties continue to litigate.